Hello, Jax West here again. Um, Facebook shut off my video, so I had to start another one, which sucks because we're on page 114 of 130. So we're like at the finish line right now. And we've been live for an hour and a half, and for it to now cut it off. So, always at beginning of all these for people, my name is Jax West. I run Stephen Avery Project, MAM Gossip, Justice with Jax. I'm also with WMP Justice Review. We are reading the state's response to Kathleen's filing that she made back in October of 2019. So it took the state, what is this, 8 months to respond. So I have the link posted right now of where you could go to read it for yourself. So we are on page, like I said, 114 of 130. What I had just read, and I'm going to read it again because I was going off into a rant and I'm not sure where it cut me off. So I want to, make sure you have this. It says, Dr. Eisenberg's testimony at trial, however, qualified the findings in her report. Dr. Eisenberg's trial testimony established that none of the material found in the quarry could definitively be identified as human bone fragments. And the FBI confirmed that the fragments could not be tested for DNA to determine whether the fragments could be identified as human or identified as those of the victim. And so what's pissing me off right here is, so you're again saying that she doesn't know if these bones that were at the gravel pit, now remember it goes salvage yard, quarry, gravel pit. So the one farthest away, the bones found in the gravel pit, these aren't the drones you're looking for. These aren't the bones you're looking for. These are not, we don't know if these are human. But then in 2011, 7 years later, you give them to the Hallback family. Why are they given to the Hallback family if you don't know if they're Teresa's bones? And then it's saying the FBI confirmed that the fragments could not be tested for DNA. Correct. At that time, they had no testing for that. But that's why it is ordered that all evidence in murder trials need to remain in evidence as long as somebody is incarcerated, because science always changes. So you cannot give these bones, and it says you cannot give away evidence unless Stephen or his lawyers say it's okay. And so what possible reason do you have to give these bones that you're saying you cannot determine if they're human? Because if you say they're Teresa Hallbach's, then you're saying Stephen left the salvage yard, which their whole case is focused on. So it frustrates me. Okay, then it continues with, from those facts, the circuit court made the reasonable inference that, quote, there was no scientific evidence or record at the time that the material was released to support that human biological material was being released or that the material was known to be the remains of the victim, unquote. The circuit court then analyzed Avery's claim and denied his motion without a hearing. The circuit court's rationale for doing so will be addressed in the subsections below. This court should affirm the circuit court's decision to deny the motion without a hearing for 3 reasons. First, Avery's claim is procedurally barred. Second, even if it is not barred, it is not cognizable in a Wisconsin statute blah blah motion. Third, even if there were a procedural mechanism for Avery to obtain relief, his claim would fail on the merits. So are they trying to say that it was okay for them to just give random bones to the Hallbach family? That's what they're trying to say? That they never said that the bones they gave the family were Teresa's? But then why give them to them? A. Avery's claim is procedurally barred because he has not established a sufficient reason for not bringing his claim in any of his prior post-conviction motions. The circuit court concluded, based upon this court's remand order, that Avery's claims was not procedurally barred. That conclusion was incorrect. As this court is aware, If a ground for relief was not raised or incompletely raised in a prior post-conviction motion or direct appeal, it may not become the basis for a new post-conviction motion unless the defendant can demonstrate a sufficient reason why the new argument was not previously raised. Avery could have raised any claim regarding the bone fragments when Avery filed his Wisconsin statute blah blah motion on June 7, 2017, his motion for reconsideration between October 23, 2017 and November 17, 2017, or his third section blah blah motion filed July 6, 2018. Had Avery attempted to investigate whether the bone fragments could be determined to be human before filing any of these motions, he would have learned of their disposal and could have raised this claim in any of them. Are you fucking kidding me right now? Even absent his request to test the fragments, Avery had the information that the fragments were given to the Halbachs before he filed his July 6, 2018 motion. On April 19, 2018, Avery's private investigator, James R. Kirby, filed a Freedom of Information Act request with the Calumet County Sheriff's Department requesting, among other things, all investigative reports on the Avery case beginning October 31, 2005. Through the date of the request, April 19, 2018. The reports were mailed to Mr. Kirby on May 29, 2018. Included in the investigative reports was the report of evidence custodian Jeremy Hawkins detailing the disposition of certain bone fragment evidence. The report was dated September 20, 2011. Deputy Hawkins' report is numbered pages 1114 through 1115. Current post-conviction counsel acknowledged receiving the investigative reports on or about May 30, 2018, in her motion to compel production filed in this court on July 3, 2018. Armed with the additional information, current post-conviction counsel could have, and should have, filed a motion in the Court of Appeals asking for leave to expand the scope of the remand order issued by the Court of Appeals on June 7, 2018, to include claims based on the disposition return of the bone fragments. Avery did not provide a sufficient reason, or any reason, for failing to investigate and raise this claim in his prior motions. The Circuit Court should have denied Avery's motion as procedurally barred, and this court should do so now because it can affirm on alternative grounds. B. If this court chooses not to apply the procedural bar, Avery's claim is not cognizable on collateral review. If this court declines to apply the procedural bar, it should nonetheless conclude that Avery cannot raise this claim in a Wisconsin statute blah blah motion. First, Avery cannot raise a statutory claim in a Wisconsin statute blah blah motion. State versus Carter. A motion under section blah blah is limited to jurisdictional and constitutional issues. So, quote, an alleged statutory violation is beyond the scope of a section blah blah motion, unquote. Avery's statutory claim has no cognizable constitutional or jurisdictional claim. Avery's claim that the state violated Wisconsin statute blah blah also fails on the merits. Respectfully, the Circuit Court decision on the contrary was incorrect. The statute reads, quote, except as provided in sub 3, if physical evidence that is in the possession of a law enforcement agency includes any biological material that was collected in connection with a criminal investigation that resulted in a criminal conviction, delinquency adjudication, or commitment under statute blah blah or blah blah, and the biological material is from a victim of the offense that was the subject of the criminal investigation, or may reasonably be used to incriminate or exculpate any person for the offense, the law enforcement agency shall preserve the physical evidence until every person in custody as a result of the conviction, adjudication, or commitment fragment has reached his or her discharge date. Okay, so saying you have to keep everything in evidence. Says it right there. Stephen is still in prison. The state preserved the biological material that was from the victim. Can you see where they're going? Or that could be used to incriminate or exculpate any person of the offense. The state preserved samples of the bone fragments that were clearly identified as being female human bone fragments. The state also preserved crime lab item BZ, the thigh bone fragment collected from the Avery burn pit, with attached human tissue. Subsequent nuclear DNA testing developed a partial DNA profile that was consistent with the nuclear DNA profile of Teresa Halbach. Additionally, the state preserved 2 tubs of cranial fragments, occipital and parietal, I don't know how to pronounce those bones, showing high velocity bullet impact in lead spray. No, it shows a trace of lead, not lead spray. See, they're wording things to make it look like, yeah, no. And fragments identified as facial bone reflective of human female skeletal anatomy. Section blah blah cannot be interpreted as a mandate to preserve in whole every single piece of biological evidence recovered during an investigation from any source. When interpreting a statute, a court gives words and phrases their, quote, common, ordinary, and accepted meaning, unquote. And a court is to interpret statutory language reasonably, quote, to avoid absurd or unreasonable results, unquote. To read section blah blah is requiring the preservation of all biological material whatsoever would read the conjunctive and out of the statute and would place an unreasonable, if not impossible, burden upon law enforcement. Law enforcement cannot be expected to indefinitely preserve biological material that had no identifiable connection to the crime. None of the bone fragments recovered from locations in the quarry were positively identified as human, let alone the remains of Teresa Halbach. Section blah blah does not mandate the preservation of suspected, unknown, or undetermined biological evidence. Therefore, the state was under no obligation to preserve those bone fragments. There is also no claim that the bone fragments could, quote, reasonably be used to incriminate or exculpate any person for the offense, unquote. The bone fragments alone, if tested, would not prove Avery innocent or guilty, nor anyone else. In short, Avery's claim that the state violated Wisconsin statute blah blah is not cognizable in a Wisconsin statute blah blah motion. And the state did not violate Wisconsin statute blah blah when it released some of the quarry bone fragments to the Halbach family for burial. Blood rising. I want to scream. Second, Avery has not asserted a true constitutional claim. Avery's motion is based on the premise that if the bones that were released to the family could be tested, and if those tests produced results favorable to Avery, those test results might exonerate Avery. Youngblood itself rejected the type of claim Avery brings to this court. The Supreme Court reasoned, quote, we think the due process clause requires a different result when we deal with the failure of the state to preserve evidentiary material of which no more can be said than it could have been subjected to tests, the results of which might have exonerated the defendant, unquote. Part of the reason the court distinguished these types of claims, quote, is found in the observation made by the court in Trombetta that, quote, another quote inside a quote, whenever potentially exculpatory evidence is permanently lost, courts face the treacherous task of divining the import of materials whose contents are unknown and very often disputed. Hard, end quote. Another part stemmed from the court's, quote, unwillingness to read the, another inside quote, fundamental fairness, unquote, requirement of the due process clause as imposing on the police an undifferentiated and absolute duty to retain and to preserve all material that might be of conceivable evidentiary significance in a particular prosecution, unquote. Avery's claim is not cognizable. Moreover, Youngblood and its progeny do not apply to the post-trial destruction of evidence. The Supreme Court's, quote, decision in District Attorney's Office for the 3rd Judicial District versus Osborne indicates that an individual does not have a right under the Due Process Clause to access lost or destroyed evidence during post-conviction proceedings, unquote. Osborne sought access to state evidence so that he could apply new DNA testing technology that might prove him innocent. Osborne claimed he had a due process right to access evidence during post-conviction proceedings so that he could do further testing. However, the Supreme Court rejected his invitation to recognize a freestanding liberty right to DNA evidence testing in post-conviction proceedings. The court determined once a defendant has been proven guilty beyond a reasonable doubt, he does not have the same liberty interests as a free man. The court further opined that establishing such a right would raise other issues, such as whether there is a constitutional obligation to preserve evidence post-conviction, which is unwilling to recognize, quote, establishing a freestanding right to access DNA evidence for testing would force us to act as policymakers, and our substantive due process rulemaking authority would not only have to cover the right of access, but a myriad of other issues. And now this is all emphasized right here, this sentence. We would soon have to decide if there is a constitutional obligation to preserve forensic evidence that might later be tested. If so, for how long? Would it be different for different types of evidence? Would the state also have some obligation to gather such evidence in the first place? Unquote. Since there is no procedural or substantive due process right to conduct, we've got 10 pages left. Due process right to conduct DNA testing and no recognized constitutional obligation on the state to preserve forensic evidence after trial, Avery has no basis to bring this claim in a section blah blah proceeding. Avery's argument to the contrary is not persuasive. In his post-conviction motion, Avery spent much time and effort arguing the state violated his due process rights when it disposed of some of the bone fragments recovered during the investigation. He asserted that Youngblood and its progeny do apply to post-conviction proceedings, citing State versus Parker. The Circuit Court agreed. A quick read of Parker does suggest that a due process violation may result from the destruction of evidence after trial. In Parker, a post-conviction counsel learned that a tape of the alleged drug transaction between Parker and an undercover officer that was not used at trial had been destroyed. On appeal, Parker asserted that destruction of the tape denied his due process right to a meaningful appeal and effective assistance of appellate counsel. The Parker decision contains no citation to Youngblood, but this court wrote, quote, the parties have not cited to, nor have we located, any case law addressing the post-trial destruction of evidence. There is a long line of cases addressing the pre-trial destruction of evidence and a defendant's due process rights. We see no reason why this line of cases should not apply to the situation at hand, unquote. There is a very good reason not to apply pre-trial destruction of evidence cases to the post-trial destruction of evidence. The due process concern in the pre-trial destruction of evidence cases concerns, quote, the defendant's right to fundamental fairness by giving the defendant a chance to present a complete defense, unquote. Avery had his trial. He is not arguing that his trial was not fair because of some issue with these bone fragments, nor that he did not have the opportunity to present a complete defense. He is simply arguing that he might is emphasized, might have a different, stronger defense if, and it is a big if, the bone fragments could be tested and is emphasized, the testing revealed that the fragments belonged to the victim. Moreover, and more problematically, the Parker decision is internally inconsistent. While the court reasoned with no analysis that there was no reason not to apply the pretrial destruction of evidence cases to a post-conviction claim, it also concluded, citing an earlier Court of Appeals decision, that, quote, a defendant may not sit back while evidence is available and then argue for a new trial on the grounds that evidence is no longer available to him or her, unquote. The state sees no way to reconcile these inconsistent holdings. Holt predates Parker, and thus Holt is controlling. And then it has in parentheses, when a decision of the Court of Appeals cannot be reconciled with an older decision, the older decision controls. Holt was charged and convicted in Illinois for aggravated kidnapping, battery, and felony murder, and then years later charged in Wisconsin for acts involving kidnapping, sexual assault, and murder of the same victim. After the trial in Illinois, vaginal swabs taken from the victim during the autopsy were destroyed. In Holt's Wisconsin trial, the prosecution introduced testimony about destroyed vaginal swabs. Holt alleged that he was denied due process when the prosecution was allowed to introduce testimony about the swabs because, quote, the state had not preserved the swabs for analysis by him, unquote. The due process issue in Holt was whether the post-trial destruction of evidence is a cognizable due process claim when the defendant is facing a new trial. And the footnote says, if evidence was destroyed after trial and the defendant did not know that evidence ever existed, that is a completely different type of claim. That would be properly analyzed under Brady and its progeny, not under Youngblood. Even in that circumstance, the court held that, regardless if Holt could establish the trombata elements, he had no due process claim. Quote, a defendant may not sit back for years while evidence is available and then successfully move to suppress testimony about such evidence on the ground that the evidence is no longer available to the defendant for further testing, unquote. Like Holt, Avery has no due process claim. There is no constitutional mandate that the state preserve evidence post-trial for further potential testing, and Avery sat back for over a decade before requesting further testing on the fragments. Furthermore, Parker conflicts with Osborne. This court must follow a United States Supreme Court decision on a matter of federal law if it conflicts with an earlier Wisconsin appellate decision. As just explained, Osborne shows that there is no constitutional right to post-conviction testing. The Osborne court indicated that Youngblood had not created a constitutional obligation on law enforcement to preserve evidence post-conviction. Osborne controls over Parker. Under Osborne, Avery has no cognizable Youngblood claim because his claim alleges post-conviction destruction of evidence, and without a constitutional claim, Avery has no jurisdictional jurisdicable basis for his Wisconsin statute blah blah motion. C. Even if Youngblood applied to the post-conviction destruction of evidence, which it does not, Avery has not met his pleading burden. In order to secure a hearing on a post-conviction, quote, in order to secure a hearing on a post-conviction motion, a defendant must have provided sufficient material, facts, e.g., who, what, where, when, why, and how, that if true would entitle him to the relief he seeks, unquote. Quote, a material fact is a fact that is significant or essential to the issue or matter at hand, unquote. Avery was required to allege sufficient material facts, quote, within the four corners of the post-conviction motion itself, unquote. As with other claims, Avery failed to meet his burden. There is a well-developed body of Wisconsin case law that follows and applies Trombetta and Youngblood. To put it succinctly, quote, a defendant's due process rights are violated if the state, 1, failed to preserve the evidence that is apparently exculpatory, or 2, acted in bad faith by failing to preserve evidence which is potentially exculpatory, unquote. Trombetta and Youngblood address the due process analysis applicable to the pretrial loss or destruction of evidence. Under Trombetta, true process is violated when the defendant shows that the state lost evidence before trial that might be expected to play a significant role in the defense. To satisfy this standard, the evidence must possess an exculpatory value that was apparent before the evidence was lost or destroyed, and be of such a nature that the defendant would be unable to obtain comparable evidence by other reasonably available means. Evidence does not have apparent exculpatory value if it would have provided, quote, simply an avenue of investigation that might have led in any number of directions, unquote. The first step in the analysis, then, is whether the bone fragments recovered from the quarry, it's not the quarry, it's the gravel pit, constitute exculpatory evidence. They do not. The bone fragments are not apparently or potentially exculpatory in any way. Avery has not established how these bone fragments are anything other than an avenue of investigation that might lead in any number of directions. Over the course of the past 2.5 years, since the filing of the original motion of post-conviction scientific testing on August 26, 2016, Avery has changed his theory of who the real murderer is at least 3 times. Initially, the focus was on individual A, later determined to be Joshua Radant, and individual B, later determined to be Scott Blodorn. Avery then shifted focus to Ryan Hilgas, who he described as the only person, like Stephen was the only one responsible, yet Brendan is in prison, who could have committed the crime, and absolved Radant in a footnote. Therefore, or shortly thereafter, in the summer and fall of 2017, Avery turned his attention to Bobby Dassey and Scott Tadek. Since that time, Avery claimed Bobby Dassey and Tadek are the killers. Notably, Bobby Dassey and Scott Tadek were included in trial counsel's original third-party liability motion as viable suspects. On appeal, Avery has added Hilgas back to the equation as well. Avery asserts only that if testing revealed that the bone fragments in the quarry, and they keep saying quarry, but it's not the quarry, it's the gravel pit. The quarry is that's Radant's. The bones in question were found in the Manitowoc gravel pit. It would establish that the victim's remains were not under Avery's exclusive control. That is a conclusory assertion unsupported by any facts. Avery never explains why, if the bone fragments belonged to the victim, it would be impossible for Avery to have planted the fragments in the quarry, or how his not having exclusive control of the victim's remains after the murder would establish or even suggest that Avery was not the killer. He fails to argue how the existence of human bone fragments found in the quarry, gravel pit, support any of his arguments that individual A, Scott Blodorn, Ryan Hilgas, Bobby Dassey, or Scott Tadek is the real killer. Thus, the only thing Avery has established in that testing the bone fragments found in the quarry, gravel pit, may lead to an investigation that could go in any number of directions. He has not established how the bone fragment evidence has apparent exculpatory value. Avery tries to do an end run around the apparently exculpatory analysis by asserting that the bone fragment evidence is material evidence because the combination of Wisconsin statute blah blah and blah blah codified a right to post-conviction DNA testing. Whether evidence is material has nothing to do with these statutes. Constitutionally material evidence. Hold on, I have to check this. Okay. I have in an hour a Zoom thing I have to do. Whether evidence is material has nothing to do with those statutes. Constitutionally, material evidence means evidence that creates a reasonable probability that, if the evidence had been available to the defense, the result of the trial would have been different. But the bone fragments were emphasized, were available to the defense, and they did not, is emphasized, make a difference at trial. The bone fragments were not apparently exculpatory. Additionally, there are fragments from the quarry that may or may not be human still in evidence available for testing. Thus, Avery has also failed to establish that he cannot obtain comparable evidence for testing. You fucked up the chain of command. Chain of evidence. So you're saying that you cherry picked some bones and gave them to the Halbach family, so that there are some bones that are still there in evidence, they're claiming, from what they keep saying is a quarry, but it's the gravel pit. And, so there were bones that were in the quarry and there were bones at the gravel pit, and they're confusing now the two. But the bones that Kathleen is talking about are the bones at the gravel pit that was then given to the Halbach family in 2011. But they're trying to say they did not have to keep those because they don't know if those are Teresa's. But then why do they go to the Halbach family? Why did the Halbach family get them if it's not Teresa? That makes no sense whatsoever. Why would bones that are not Teresa go to a funeral home that Teresa's mom signed for? So they're trying to say they did not have to hold these bones because it's not Teresa Halbach, but you gave them to Teresa Halbach's family. And if you now were to go through these bones that you left, wouldn't somebody say, well, how do you know those were the bones? Because this box has been opened and some bones were given away. And do we know, has it ever been determined if the bones were they cremated? Were they just buried? Now, I did a video. We went to Teresa's burial. So there is a plot for her. So are there bones there, or did they burn the bones? Regarding the potentially exculpatory standard under Youngblood, Avery has also failed to establish that the bone fragments were potentially exculpatory. A criminal defendant must show bad faith on the part of the state when the state fails to preserve evidence, quote, of which no more can be said than that it could have been subjected to tests, the results of which might have exonerated the defendant, unquote. Absent such a showing, there is no due process violation. Avery has not established any potential usefulness of further testing of the evidence found in the quarry. You mean gravel pit. At trial, defense counsel made use of the state's inability to discern whether the fragments recovered from the quarry were human. Avery does not argue how a definitive determination that the fragments were human is material. There is no discussion of how or why these remains being found to be human would support a claim that Avery was not the killer. There are no asserted facts establishing how, if the quarry bone fragments are human, that Avery would have a viable third-party suspect defense under the rules of State versus Denny and Wilson. There is no analysis of motive, opportunity, or a direct connection to the crime related to these fragments. Avery offers no fact or analysis demonstrating why it's not possible that Avery himself or his convicted accomplice, Brendan Dassey, Brendan's not his accomplice in Stephen's case. There is no Brendan in Stephen's case. Placed the bones in the quarry to divert attention from himself and escape detection. Avery fails to tell us how a possible third location of Halbach's remains possesses any exculpatory value, because you said he never left the salvage yard. Even if Avery could establish that the bone fragments were potentially exculpatory, which he has not, he failed to establish that the state acted in bad faith. A defendant can prove bad faith, quote, only if 1. The officers were aware of the potentially exculpatory value or usefulness of the evidence they failed to preserve, and 2. The officers acted with official animus or made a conscious effort to suppress exculpatory evidence, unquote. Avery established neither. The state released some, but not all, of the bone fragments on September 20, 2011. By that time, this court had issued a decision denying Avery's request for a new trial. The bone fragments were not part of Avery's direct appeal. There was no pretrial request made by trial counsel, and there was no request by appellate counsel during direct appeal to examine any of the bone fragments at issue. The state made reasonable efforts to determine the identity of the bone fragments at issue when it sent the items to the FBI. It has FBI bolded. The FBI could not test the items. When these items were released to the family, the state did not know their origin. The state did preserve the bone fragments clearly identified as the remains of Teresa Halbach and those that could be identified as being female human bone. Under those circumstances, there is no bad faith. Avery is due no relief. Why are you giving bones that are not Teresa Halbach to the Halbach family? Explain it. Explain it. Six, and we've got 2 pages left. This court lacks jurisdiction to review Avery's motion to compel discovery. Avery complains that the circuit court, quote, never ruled on his motion to compel discovery. He filed on July 3, 2018. He doesn't actually make any argument or claim related to it, though. It appears to just be a lament that is unresolved. Regardless what argument Avery meant to make about this motion, this court lacks jurisdiction to review it. Motions seeking post-conviction discovery under State v. O'Brien are considered section blah blah motions pursuant to blah blah, meaning Avery's motion to compel discovery of the state's 2018 examination of the Bobby computer was a new action in the circuit court. Quote, an appellate court has no jurisdiction to review the denial of a post-conviction motion if there is no final written order denying the motion on file in the office of the clerk of court, unquote. Again, why in 2018 did the state get Bobby's computer again? Why did Barb keep that computer? Why did Barb willingly give them that computer? Why did Barb not give it to Kathleen Zellner? Avery never received or requested a final judgment or order denying this motion. No written order was entered as required to bring it before this court pursuant to Wisconsin statute blah blah. This court lacks jurisdiction to review arguments about this motion. Conclusion. Here's the final paragraph. Though Avery raised a litany of claims in his motions, none of them entitled him to a hearing. The circuit court properly exercised its discretion to deny his motions without one. This court should affirm the circuit court. Dated this 27th day of March, 2020, respectfully submitted, Joshua Call, Attorney General of Wisconsin, Lisa Comfer, Assistant Attorney General. So, the things that stand out to me First of all, I'm not even going to get into the legal stuff because I don't know the legal stuff. I don't understand the legal stuff. I think the legal stuff is bullshit. I think it is bullshit that you have to find another case that did the same thing that your case is in order for you to be able to use it. That just has never made any sense to me, and it's just legal bullshit. I'm gonna say bullshit over and over again. Sorry, potty mouth. Shows I'm not intelligent. I got it. So everything in here is just trying to block Stephen's reasonable points, is that you didn't show this thing, you didn't show that, you should have filed it here, this wouldn't have changed it, you could have, if you had just done better research, you would have known this, blah 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 blah. As we know, with following this case and following all these cases of the wrongfully accused and convicted, the court could very well rule in the state's favor against Stephen with using these legal loopholes and bullshit. But the things that pissed me off, that stood out, are they're now trying to say that the bullet, the magic bullet that they keep using and infer shot her in the head, didn't go through her head, so there wouldn't be any bone matter on it. So now they're claiming, without any evidence of anything, that Teresa was shot more than in her head. That's a big one. That it's really like, what? And then they're trying to say they get around the whole statute or whatever it is that you have to hold on to evidence, is that, well, this evidence, the bones from what they call the quarry, but is the gravel pit, isn't Teresa, therefore it's not part of his case, so they don't have to hold on to it. And it's an undue burden for them to have to hold on to all the evidence. Bet you'd think differently of it if it was you or one of your loved ones in prison and they just threw away evidence that could exonerate them or you. I don't like to talk negatively about the Halbach family. They are victims here. No matter what happened to Teresa Halbach, they lost their loved one. Why did you take bones then that are not Teresa's? Why did you accept those bones 7 years later or whatever that was? That makes zero sense to me. If this is not Teresa, why did you take them and bury them with her? If any of the bones you've been given the whole time are even Teresa's. I am not convinced that they have proven any of those bones are Teresa Halbach. I am not a conspiracy theorist. I do not believe Teresa Halbach is alive. The only thing that I know is Stephen and Brendan are innocent. There is absolutely no evidence that proves either of these men. God, and Brendan is a man, and it's weird to say that either of these men did this. Nothing. And for our legal system to make things so complicated to overturn false convictions or wrong convictions, there's just so much wrong. How do you fix it? How do you even start? I don't know. I don't know what the answer is. But it shouldn't have to take an average of 15 years to get somebody out of prison for something they didn't do. I don't care how much money it costs to store evidence. You want to take somebody to court and charge them with the crime? That goes with it. Sorry, it just does. Cost of doing business, right? So they're claiming the bullet, the magic bullet, didn't go through her head. And they're saying it's okay they give bones away because we don't know if it's Teresa. So it's okay if we just give it to the Halbach family. So does that mean I could look up like a famous case and go, what evidence do they still have? And go, ooh, I want that. Just give that to me because it's something that was part of the trial, but it's kind of, we don't know what it is. So can I just, file a Freedom of Information Act and get that evidence? You don't need to keep it. Lynn says, there is no firm evidence that Teresa is a victim. If we question the evidence and there is zero evidence, then we can't pick and choose. Halbach had lots to say before and during trial, and now they are moot. Doesn't sit well with their current silence. Right. That's, while I say what there is points to Scott and Bobby, I can't say what Scott and Bobby did to her. There's no evidence of what happened to Teresa Halbach. We just know she has not been seen since that Halloween. That's all we know. That's the only fact there is. Well, Ty says, I'm ashamed of the state of Wisconsin, and sad part is I'm from Wisconsin. I really say let them free. The state evidence is BS on Stephen and Brendan. Well, Ty, it's not just Wisconsin though. And I don't want people to brush Wisconsin, in one stroke, because there is good and bad everywhere. There are good cops and bad cops. There's good lawyers, bad lawyers. It's everywhere. Manitowoc County has an infestation of bad law enforcement. In Illinois, we have Lake County, Illinois, is actually known as the wrongful conviction capital. I'm going to start doing videos, starts next Sunday, June 7th, on the WMP Justice Review Facebook page. We are going to start going every week into one of the wrongful convictions or corruption in Lake County, Illinois, to just shine the light on that. So it's not just Wisconsin. Wisconsin, I spent my summers there as a kid. It's, a beautiful place. Manitowoc has a lot of really cool places. I've been there a few times. So people need to focus on Manitowoc County Sheriff's Department. And then you've got Calumet, got Kratz. I mean, the people that are involved in these cases, not just anybody who's in Manitowoc. We enjoy camping says, what are the chances the courts will lean towards the state's response? My opinion, I'm a pessimist when it comes to all this, and I just think the court's just gonna side with the state. They're gonna say all this legal mumbo jumbo stuff of you should have filed this then and blah 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 blah. My thought always is that the court, that thin blue line thing, they're gonna cover for their comrades. for me, all the evidence is there that shows that Stephen is innocent and he should be out and he should own Wisconsin. But I don't believe in our court system that Stephen will be out. But he does have Kathleen Zellner, who is one of the best, and she's on it until she gets him out. So Tiffany asked, have you looked into Ivan Cantu in Texas on death row? No, I have not. I've got several cases that I advocate for, and the WMP Justice Review team is taking on a bunch more cases, and I'm going to have to be looking into those. So and now I have to start looking into these Lake County cases that we're going to cover. So I've got a whole bunch on my plate right now. Lynn says, right, Jax. Just the other day, we watched law enforcement kill a man via video. Many states are dealing with corruption from law enforcement all the way up to state and federal levels, unfortunately. Yeah. So what we wait for now is Kathleen. Her response is due on June 11th. Hold on. June 11th is a Thursday. So typically, things like they call it the, Friday dump. Usually on Friday late afternoon is when stuff gets dumped. And I've got my thing in half hour. So June 11th is when her response will come. And then is it the court has 30 to 60 days after that to respond, to rule? I don't know. But as soon as Kathleen's response comes out and we get it, we will go live and read it here on Stephen Avery Project. I will be going live in our subgroup, which is called MAM Gossip. I don't know if it'll be today or when it'll be, but we're going to do a live where we discuss the state's response. We're not going to read it. We're just going to bitch about it. So if you're not already a member, it's a closed group, MAM Gossip. But just know before joining in that group, we talk about other cases there. So we do have people that come in there and will complain, what does this have to do about Stephen? Well, it doesn't. There's many other people that are wrongly convicted, and we want to discuss those cases too. So those are talked about in MAM Gossip. So, and in Gossip is where we do delve into more of Stephen's case. We've got a lot of really good investigators and researchers in there who find some really interesting things. So that's an MAM Gossip. So I'll go live in MAM Gossips at some point. So we'll discuss this and just bitch about it. We'll go live here around June 11th when Kathleen's filing comes in. So, all right, I am going to clock out. Let me post again before I go for the people who watch this not live. Just so you have, again, I know I try to keep putting it everywhere, but here is the state's response that I read. So you can read it for yourself if you would like. Okay. So, all right, I'm out. Investigation continues. See you next time.